Hello, my name is Liisi Jürgen. I'm attorney at law at NJORD Law Firm, also partner of NJORD. And here is my very good colleague and dear friend, Jelizaveta Henno, also attorney. And we are those two lawyers who were honored to draft the Estonian first Space Law Act. And today we would like to give you also a small overview of this legal act, which is not ready yet. The first draft is right now circling between different parties and also different ministries, but in few weeks it should be confirmed, and then the administrative processes will go on.
Yes, thank you also from my side. And this law is like first draft is ready, and as Liisi mentioned, now it's time to discuss it, to adjust, to ask questions, and to move to the final version of the law. First, to explain that our Estonian national space law is actually based on international law, which is a great basic regulations. So it is not something that we are designed from zero, but this is based on main international conventions like Outer Space Treaty, Registration Convention, and Liability Convention. This is like framework, international framework for national laws, which were created in 16th and 17th of the last century, when there was like race between Soviet Union and US to demonstrate developments in space, but now it's still valid and still creates like ground or basics for creation of national space laws. So if a state want to have their own space law, then we should take into account that the issues that are provided here that we have to regulate. And one issue is that country should create a procedure for processing licenses, space licenses, for control of space activities performed by non-governmental actors, to have a register of space objects, and to transfer data about orbital parameters of national objects to United Nations register. And there is also liability questions, since current model of space law presumes that yes, space is not related to any country. It's in public domain, and it's global common, like open water. So any nation can launch object into space. But if something happened, some damage incident in space, then the state under flag of which the object was launched is responsible. This is like a current state of matters in terms of liability, and we incorporated it, considered it when drafting our national space law.
And as you can see, then national legislators do not have too much freedom to draft their legislations. They need to be accordingly to international law. So, and here you can see also that there are not too much free room to regulate themselves something different.
Yeah, basically this is a minimal set of topics that should be incorporated and regulated in national law. And in Estonian law, Space Law Act, and considering the future and considering possible European Union regulation of space activities, we have elaborated and incorporated three basic principles. It is safety, that space activities must be safe, of course, and there is some procedures how the operator should demonstrate it. Then expertise, it is assumed that operators have some set of qualification, education, or experience because it's the space activities is not the easiest area, and it's an area related to state liability issues. And the third one is environmental sustainability. It's directly related to preventing, mitigating space debris, and it assumes that operators should think about environmental impact of space activities in the very beginning when they're applying for a license, and to present to the state their vision of their plan, how they are going to mitigate the risks for environment.
So those three principles are the main principles what the operator and also regulator should keep an eye on when they are preparing space activity during the active permit, and also later when they will like to wrap up their space activity, then those three principles are still valid.
And here is a general structure of our Estonian Space Act, like a draft. Currently it's a draft, but I think more or less these are like main topics, and as usual for Estonian legislative practice, first agreement describes the purpose and scope of the act. So the scope of the act is national space activities, and it is possible to, these activities are allowed for government and non-governmental institutions, and also for the purpose of enterprise, for science and development. So the purpose of space activities are not limited, but it should be considered, but it's important in case of exemption, which we will discuss later. Then duties of the competent authority, so the set of topics that Estonian authority check and control, principles of space activities that we have mentioned already. Then there are requirements for operator, and there is no so much requirements actually. It's one basic requirement is that operator should have self-control. So it's assumed that operator know or like understand what type of space activities they are carrying out. They have a system of control, they know the location of their object and can provide information to the state, specifically about the orbital parameters. In case of accidents, they should inform. So this is quite basic things. Space license procedure, how to apply for a license, which documents and requirements are valid in the course of applying. As I mentioned, operator self-control obligations. Then one important topic is registration of Estonian of objects launched under Estonian flag. So this first we will explain in more detail after that there will be a separate database created for that reason. And then one topic is transfer of space objects and space activities, because we cannot exclude that for economic reasons, for reasons of development, it might be important to transfer these activities from one entity to another or object, but there are some rules that regulate the possibilities of transfer, which is not, I would say, easy, but it is actually related to, again, liability, to national security issues. So it is basically should be coordinated with the state in order to transfer object to activity. And termination of space activities is also one important topic, because now from the very beginning when applying for a license, it is important that operator will think not only about successful launch of the object and how they will communicate with the object in the space and things like that, but also what will happen in the end of the mission, how they are see termination process. So taking into account that we would like to avoid space debris and to be sustainable and be in line with European regulations that would one day will apply and enter into force. And right to recover damages compensated by the state. So this is related to state's liability if under international law Estonia, let's say, will have to pay something to another state due to some accident with Estonian space objects, and then Estonian state has right to claim this damage from operator. So this is a general principle actually of liability. Who brings damage, that entity or person is responsible. But since there are very specific regulation in case of space law that the state is international liable, then we created as actually based on practice of many other states this right of recourse. So state can claim damage that they compensated from operator who actually caused the damage. And insurance, also one important issue. There are some general requirements for having insurance, and the classical topic is supervision, because state then create procedure how they will supervise activities and operators.
Yeah, the list here, what you can see, we have to keep in mind that we were also not completely free to put this structure together. Estonian law is rather specific to regulate how one legal act should look like. And this is also regulated. So this list, which describes the structure of the Estonian space law, is actually also given, so to say. We had a little bit more free hands to focus on self-control and self-regulation of the operator, and we tried to keep it also rather so that the operator has its own responsibility to regulate themselves, to have internal rules, to put together internal proceedings and processes, how to follow then those three main principles what we had on the last slide.
Yeah, to supplement, the state doesn't prescribe very specific rules how operators should control themselves, because it varies. It depends on complexity, type, and scope of space activities. They can be very different, and objects can be very different. So here it's like a balanced situation when we assume that operator is responsible and reliable and perform their duties, and states can check it within this supervision procedure.
Then something additional also what maybe other countries do not know, or it is a little bit unrecognized for them. Estonia is e-state, which means that all administrative proceedings are taking place in electronic or in a digital form, and that's why we have also here mentioned also this database, or correct is to say data set, registration of space objects and also registration of operators. This will be then full electronic or digitalized administrative process, like every administrative process in Estonia mostly. And here those are typical legislative parts for Estonia as a state.
And here are a list of duties of Estonian regulatory authority. It will be Consumer Protection and Technical Regulatory Authority in Estonia, and these are like basic issues that will be under their supervision. First, this authority that will grant, process, amend, supervise space licenses. Also, this authority is responsible for registration of space objects and ensuring that data is correct. Also, if you want to transfer or space activities or space objects, then they are competent to coordinate this. They perform supervision, and also one important function is transfer information to the United States. So to be compliant with international requirement that each state should submit data about space object launched from their territory or on their flag.
Estonian law is similar to the German law, so if we have here someone from Germany, then they know rather well that administrative bodies, they have rather strict list of rules, and usually it must be regulated in law or provided directly in law. They can't make up by themselves their own tasks, so this principle is also followed here in Estonia. So also all the tasks, authorization, power of attorney, all kind of freedoms and obligations are a full list regulated in law, so that all parties, regulator itself and also operators, citizens, others have then very clear understanding what the regulator may or may not do.
And how to acquire a space license? Well, here is just very short summary of the process, but basically you need to submit application and document attached set of documents, and these documents include information about education, qualification, work experience. We understand that in Estonia specifically there is no education specifically in space for space activities, but there can be related areas, engineering, infotechnology, cybersecurity, and
but also maybe also finance, whatnot.
Yeah. Mm-hmm. So it's issue of interpretation of law. We don't mean that it must be like some diploma regarding space engineering. So taken reasonably. Then it should be described which activities you are engaged in, description of a mission, so it would be possible to understand duration of mission, which objects you are planning to use. Then internal rules. This relates to self-control obligation of operators. So these rules describe some issues about organization of operator, and it demonstrates that you have staff required for specific type of space of activities, that you have system in place how you are going to report about accidents, to inform state about some maybe damage or substantial change of orbital data. So you have this line of of information moving. And then it's also important that in the beginning you are thinking through about risks that are specifically related to the type of mission, and you describe them, and these are not only technical, physical risks, but also cybersecurity risks, and so it's tasks of operator to disclose this information. Then it's also important that, as mentioned before, you have environmental impact assessment. You have some plan how to mitigate the space debris, how you will avoid damage to environment, or what kind of damage you can foresee depending on the type of mission and object. Space activities termination plan. How it's deemed to terminate activities. This depends, of course, on technology, whether this satellite will burn up in atmosphere or you can bring it to the Earth somehow, or what will happen, because this is one important issue, to terminate the space activities in compliance with all these three principles, and not just to forget this object somewhere into space. Insurance, this is also very I understand, restrictive requirement, but we haven't seen any state law that wouldn't have it. The question basically only at how severe, how strict it is, and so we choose like I think quite reasonable approach. But this is like a general rule that insurance should be concluded and presented when applying for license, but under exemption it's possible to avoid this requirement if some certain requirements are met. Data about space owner of space object, because in practice it's understandable that space object operator and owner can be different persons, can be different entities. Ownership is something separate, and but in that case, state should be presented data about state object and how under which basis operator is going to use this object. Are there some type of agreement between owner and operator? And other persons involved in manufacture of space object. So this is like very actually big concern when we consulted with different states, that they mentioned that when they created their space laws, that they didn't think about this subject. But actually it is important for the state to know and to be sure that there are any high-risk actors, bad actors involved in process of manufacturing of the space object, like for example terroristic organizations, and it should be possible for state to validate that there is no such relations. And last one to mention information about cybersecurity of the control center. So this is something that will be more and more important in years to come, the cybersecurity issue in space, for space activities, and this should be like one element of security principle.
Here must be also taken into account that the Space Law Work Group, or Jelizaveta and I, we didn't made up this list fully by ourselves. It's also kind of like compromise between Defense Ministry of Estonia, between Internal Affairs Ministry of Estonia. So they all had also their ideas and the proposals, rather strict ones actually, as well. So this is kind of like compromise between all those different authorities as well, who provided also their ideas and understandings how the space license should be given out and issued, and what kind of data should be submitted during this process.
And now we reached the topic of exemption, and in Space Law Act we have separate regulation for obtaining exceptions. And like the main idea is that you can skip this general process when you required to submit 100% of all the documents, insurance, etc. And if you if you go under one of three exemptions, then this procedure could be easier, but the substantial requirements should be met. And like general idea is that still the principle of sustainability, security and expertise should be followed. So it cannot be just some very dangerous thing. So it must be still be safe. Competent authority has a right of discretion, meaning like right to decide like if to apply and which exception and what will be like this exemptions, like what rules you can like skip and be freed of. We tried to, when drafting this exemption, to avoid discrimination, meaning that
different sizes of companies cannot be discriminated, or so we would like.
Or even like a region of applicant. If you are registered under Estonian requirements, then you can apply also under exception. And of course there are some specifics regarding two exemptions are related to scientific purposes, and one is now under like we are working on it. It's would apply more generally in case of enterprise commercial activities as well.
But here must be kept in mind that as a state has rather huge liability, then these exceptions may not become kind of like easy license to do some criminal activity or some more risky activity under this exception. So here a regulator will have rather huge responsibility to evaluate first that if applicant is entitled to receive the this exception, and according to which requirements we will loose down a little bit then.
And first exemption is meant for space activities that are performed from a space station, provided that the station is orbiting lower than 450 kilometers, and there is a limitation for performance of space activities which should be shorter than 2 years. And this 2 years starts from a moment of deployment of the space object. So it doesn't include time you need to develop the object, to construct, to manufacture it, and to launch into space. But it 2 years from this successful deployment, when it separates from the carrier. So you have these 2 years to perform space activities and also finish. And here we doesn't how to say, it's not important whether it's purely scientific or development purpose. It can be currently, we think so, also maybe some kind of commercial activity.
Yeah, here must be taken into account that it is not yet confirmed. So policymaker can also make here changes as well.
So then second, this is for specifically for research and development purposes, and this should be demonstrated and proved by operator that their mission are related strictly to scientific or development purposes, and are not related to any commercial use of space object. And this is like first criteria, and second, it is possible it's for missions that are performed on the surface of celestial bodies. So it's maybe more for future currently designed.
And we have a third exception as well. And here are also a few aspects which are still not yet confirmed, and those suggestions for this legal provision came rather late, a few weeks ago, so it is still a little bit like maybe not that settled down yet. This exception is based on the risks, how risky or unrisky the space activity is, and then the regulator may issue a permit license, space license, then based on this exception.
Yeah, it's like very low risk should be demonstrated, but it's under the process of designing or confirming.
And our time is almost up, but then also the last aspect, as Estonia as e-state as well, like I mentioned, then our administrative processes are usually run electronically. So this means that applying space license or registering the object means that you need to have some sort of device, you need to have internet connection, and this means that you can then submit your documents electronically. You will receive also all kind of replies from regulator also electronically. The purpose is to avoid all kind of paperwork, like physical paperwork, and also to keep the administrative process as smooth, as paper-free as possible. So environment-friendly one digital process can be. And then it doesn't run randomly. It is also regulated here in Estonia as well. We have for that also specific laws, and those laws has been taken also account to give then this allowance to provide new data set, and this data set will be this tool for a regulator where all the data will be kept and where all the communication between operator and the regulator will take place then. So our time is up, but maybe 1-2 questions we can then have. The one aspect what I would like to stress out that those conditions or requirements came up also very short time ago, like few weeks ago. So we don't know also what is the reaction from other ministries like Defense Ministry and Internal Affairs, so on. So I can't really confirm that it will stay in a place like it is right now here on the screen. But nevertheless, different appointments what we have had, different meetings what we have with different interest parties, they have pointed out that maybe to allow some exceptions then for those operators who can prove that their activity is rather short then, certain time limit, like 5 years for instance, and then also that they can approve that their space activity is rather safe than. Those requirements are then based on that. Those are not, we as lawyers, we didn't make those up. Those we received like input from engineers.
But actually propulsion system is some kind of technical solution or issue that made by human, and it can help to prevent collision, can be very helpful, but on the other side it can make mistakes. We cannot exclude it, and it can maybe be in some aspects even more dangerous, depending how designed, how managed, software issues, everything. That's why if you use such type of technology, then it is expected that it's really low risk technology, and for that it is offered 1 to 1,000.
But as those list of requirements are rather new, then we are actually, and it is not confirmed, and we are rather open. If you have some other ideas, then we are also happy if you can email later also when you have other thoughts regarding that provision, for instance, or that clause. Here. Oh, there was one gentleman, and then is one young gentleman here. We are using microphones, so if you want to. Yeah, the rule is that Estonia is part of EU, and EU has one big principle what EU member states must follow. It is a technology neutrality principle, which means that legislators, it's not recommended that legislators will say that certain technology is allowed and certain technology is not allowed. This is not the task of legislator. Legislator's task is to provide very clearly that, aka the system must be safe. How this safeness has been reached is up to engineers already. It's not up to lawyers to say what is safe, what is not safe. And that's why we try to avoid also all kind of specific standards or specific technological requirements. This is something what every time must be evaluated by the operator by itself and then together with regulator as well. Regulator is the last one then which will look, everything is done now, here is your permit. But we cannot put clear standards into the legal text because today they're accurate, tomorrow they're already old and inaccurate, and we can't change all the time the rules. Plus, we have to support also different technologies as well. Under the word safe can fit very different technology. So it's not legislators or policymaker task to give some sort of limitations to different technology or any kind of standards in legal text. This is a rule of law everywhere. Do we speak about medicine, I don't know, car industry, whatever industry will take, in legal act yourself you can't see standards. You see another legislative or other documents where the standards are.
Yeah, we haven't written into law the name of the organization because it can change in time and it's a matter of interpretation, but the main requirement that is that this organization should be competent and independent in that sense that it shouldn't be associated or related somehow to the operator. So it's not like a subsidiary issues certificate that is safe. So it must be competent organization, probably intergovernmental organization that providing launching, for example, services. And but if we will put name of the organization, then most probably we need to change law like in a year or something. It's not like Estonian legislative tradition.
Mm-hmm. Any other question or this is? The lady here. The last one, then time is up.
So, 2 questions, in fact. So, you mentioned that to acquire the license, is that for manufacturer or operators first? And the second point is because you mentioned that you have to have the name of person involved in manufacturing.
The thing is that the permit is issued for operator, but the operator must have understanding who is the owner of the space object. Sometimes the base object may have different operator and owner. They may be different persons, different entities. I am the owner, but you are the operator, for instance, and we have one object, yeah? This can be the case. So the operator is the responsible person to give overview for the regulator who is the owner of the object and what is the legal base according to which the operator is allowed to use or operate the space object. Is it an agreement, legal act, whatever can be the consent, whatever can be the legal base here. And second, yes, we had meetings with different states, different legislators from different states, and then also Denmark was the one, I think, which said that they have had problems regarding that sometimes they understand that the main parts are from third parties, manufacturers, and they don't have any legal base to ask information about those manufacturers. So this helps also the regulator to understand how this object is put together then to receive information about the manufacturers or the main parts of the object.
And we don't have different types
for companies or subsidiary, but person, it's the protection of the person is strange that you mentioned that you would like to have name of person involved in manufacturing. So it's
Obligated person is operator who has who must have the information who is the owner of the object and who are the main manufacturers of the object.
State of origin, name of a manufacturer.
Okay, name of manufacturing, but not person.
No, not my name, as Liisi Jürgen, but name, business name was. Yeah.
Yeah.
No, actually, the time is up. I don't know. Is the organizer allowed? Or? No. Your question then. We can't hear you.
Okay. My question is going to be something more specific, I think. There is a chapter mentioned in the Space Act under how to acquire a space license.
We can't really hear you. Can you speak up?
Okay. There is a chapter mentioned in the Space Act under how to acquire a space license, information about the cybersecurity of the control center. Can you explain it further?
The cybersecurity are part of IT and everything. So if you can't these days do anything without IT, which means that cybersecurity applies. And this means that also the operator must be able to prove that the object, space activity is covered by cybersecurity rules as well.
Yeah.
And in Estonia, cybersecurity has its separate legal act, and operator is obligated person according to this legal act, which means that the cybersecurity legal act is already ready. You have to open it, make the requirements clear for yourself, and then also development process or any other IT-related activity is then regulated by the Cybersecurity Act, and so it is.
Basically, how the IT system and data is protected, integrity, safety of data, how it's protected, which measures you use for that. So the more detailed requirements are indeed stipulated in another legal act, Cybersecurity Act, which relates to a wider regulation coming from EU. So this is like a chain of legal acts.
The Cybersecurity Act is also not purely Estonian legislator own work. There is some parts, but there is also EU influence rather big. Thank you. Yeah.
That so you assess the knowledge of these professionals because it's under the how to acquire a space license. And I wanted to ask actually, how do you measure the knowledge after giving the information that is defined as competent?
Excuse me, can you repeat yourself?
Okay. I wanted to ask that I assume that you assess the information, basically the knowledge that is given to those persons.
Yeah, of course. Like every regulated area, like medicine, finance, like what key persons have to have some basic knowledge.
Yes.
And that's it. And how you prove it with CV data and the diplomas. So
basically, competent authority is leading the process, and first you submit everything that is required by law. There is a quite precise list of things, and then it's a general administrative procedure rule that if competent authority thinks that there is something missing or needs some more explanations or some documents which relates to the procedure, then they can ask, and then you can supplement. If you, for example, presented data in not quite required way, then they can ask you to correct it. So they are leading this process. But to start, you have to be sure that everything that is in the list you submit, and then it would go more like smoothly in that sense.
Thank you.
Thank you.
Thank you.